Okay, well, good morning, everyone. Welcome,
Morning.
and let me extend my thanks to all of you for attending. It's great to have you. My name is Tom LaGreca, the Executive Director of Medical Revenue Recovery at Callagy Law. I would just like to spend a few minutes introducing the team, introducing the subject matter. Um, the During these trying times, let me just say at the outset, there are things we can control, things we can't control. Always, we have to try to look, as I'm sure all of you would agree, on the positives. We have to try to keep things relatively normal and move along with life as best we can. We're hoping that this webinar and this series of webinars will help all of you to do that. We have other webinars that are coming up. You've probably seen notices of some of the webinars we've had. Today's webinar is about jurisdiction in the context of workers' comp court. It is one of the hot button issues in workers' comp world, and it tends to be a little more complicated than meets the eye. So we thought this webinar would help to clarify some of the issues and some of the nuances. As Krista mentioned, if you do have questions, we'll be taking those throughout the presentation. Use the Q&A section to present those. Do not use the chat section. So with that, on the presentation panel today, we have our esteemed workers' comp attorney team, which includes Raj Bardwaj, it includes Krista Spinelli, and it includes Iwana Enescu. They are doing an incredible job keeping respondents and carriers on their toes. They have been at the forefront of the jurisdiction discussion really from the outset of their time with us, and they are fighting the fight, not only workers' comp court, but also in front of judicial courts where the issue is currently pending. Let me just say something real quick about jurisdiction, and then I will bring Raj in, who will start off the real meat and potatoes of the conversation. So when we say jurisdiction, jurisdiction really means power or authority. So if I say New Jersey has jurisdiction over a dispute, basically what I'm saying is New Jersey has power to hear and resolve the conflict. To do that, the state of New Jersey needs two pieces. They need to have power and authority over the series of events that underlie the lawsuit, but they also need power and authority over the parties to the lawsuit and the one being sued in particular. Because the party that's doing the suing, if they sued in New Jersey, they're agreeing that New Jersey has jurisdiction over their person, but the one being sued may not. So if I have a dispute with somebody in New Jersey and I go to Hawaii on vacation, and while I'm in Hawaii, I decide to sue that person in Hawaii that I have the dispute with in New Jersey, Hawaii is going to say to me, what are you doing here? First of all, we don't have power over the events that took place because they may have taken place in New Jersey, but we also don't have power and authority over the person you're suing because they're in New Jersey and they've always been in New Jersey and they've never even been to Hawaii. So there's two components to jurisdiction. One is the series of events underlying the lawsuit, and the other is the person that you're suing. So let's put that in a workers' comp context. There are lots of people in northern New Jersey who work in New York City. There are lots of businesses in New York City that conduct business in New Jersey and vice versa. There's a lot of interaction between the states of New York and New Jersey in the north and between New Jersey and Pennsylvania in the south. This raises all sorts of questions as to jurisdiction of any dispute, including workers' comp world. So when you have a New York employer, for example, and a New York injury and a New York carrier, but the treatment takes place in New Jersey, this raises interesting questions about jurisdiction, okay? Regarding the subject matter piece of that, We take the position that the circumstances underlying the patient's claim in workers' comp court are where the injury occurred, et cetera, et cetera. But we take the position that the medical provider, the circumstances surrounding the medical provider claim are actually the medical treatment. So that we take the position New Jersey has jurisdiction over the medical provider's workers' comp reimbursement claim as long as the treatment took place in New Jersey, okay? The patient may have to go to New York because the circumstances underlying the patient's claim may be centered in New York. But we believe the treatment is the set of circumstances underlying the medical provider's claim against the carrier. So that's what we mean by subject matter jurisdiction, and that's what Raj is going to focus on. Krista is going to focus on the personal jurisdiction piece, which means even though the circumstances of the medical treatment take place in New Jersey, so New Jersey might have jurisdiction, subject matter jurisdiction over the dispute, New Jersey still needs to have jurisdiction over the employer, the carrier, the person who the medical provider technically is suing in workers' comp court. So that's just to give a little context to the difference between subject matter jurisdiction and personal. We're going to try not to get too much in the weeds of the legal terminology, but I just wanted to give a little context to the discussion. So with that, I will turn the presentation over to Raj, whose focus will be on the subject matter jurisdiction of the matter, of the issue. So here you go, Raj. Take it away.
Thank you so much, Tom. So to give a little bit of context of when these issues are arising, right? So we have essentially fact patterns. Sorry about that. So we have fact patterns where the injured worker resides out of state or is employed out of state. Their accident has occurred out of state. In most instances, we're seeing this with New York and Pennsylvania workers because they're the closest neighboring states to New Jersey, and they get injured in their out of state, out of New Jersey. They perhaps reside out of state, and their employer is located out of state. Now, we also have seen situations where the injured worker is from California, the injured worker is from Texas, the injured worker is from Florida, and essentially, like Tom was saying, our position is that where the treatment occurs, and the treatment always occurs in New Jersey, is fundamentally where the court should hear the dispute. So, so I kind of want to go over where the courts have been regarding this issue, where they are now, and sort of where they're going. So we've been involved in this jurisdiction issue for a very long time. Our position has never changed that it's a contractual claim, that the basis of jurisdiction is where the treatment occurred, where the breach of contract occurs. And it has particularly become an issue since the 2012 amendment. And I'll briefly explain what that means. So before 2012, the Superior Court, so the general court in New Jersey, would oversee these disputes where there's an injured worker, a doctor treats the injured worker, and then they have some dispute, usually with the insurance carrier, regarding what the appropriate reimbursement should be. So in 2012, there was an amendment to the workers' comp statute, which gave exclusive jurisdiction to the workers' comp court to review these issues of reimbursement to medical providers when they've treated an injured worker for an accident that occurred during the course of their employment. So after they gave the workers' compensation court exclusive jurisdiction, now that creates a few interesting questions of law. So I'll give both sides of the argument. I'll give the carrier side of the argument and the ones that a lot of judges take, and then we'll give our side of the argument, which also the majority of the judges that have written opinions on this issue have favored our position on jurisdiction. So the operative statute, right, and I'm just gonna, I don't want to get it too much into the legal jargon, but I'll briefly state it. NJSA 3415-15 states that exclusive jurisdiction for any disputed medical charge arising from any claim for compensation for a work-related injury or illness shall be vested with the division. And the issue is all about how do you interpret this operative statute, which gives the Workers' Compensation Court exclusive jurisdiction to oversee these medical provider disputes. We know when it comes to the workers' compensation claim for the injured worker, when they file a claim for benefits, there are certain jurisdiction parameters that they must fit into. So, for example, here are a few. The employer's connections to the state. Where was the contract of hire? Where does the employer reside? Where did the injury occur? Where is the employer doing business? All of these factors are considered when determining whether the court, the Workers' Compensation Court, can hear the injured worker's claim. Now, some judges and some insurance carriers argue that the same jurisdictional parameters should be applied to the medical provider. The medical provider who has nothing to do with the injured worker's claim for benefits. They just treated the injured worker in the state of New Jersey and now are disputing whatever payments they were given. So what we try to do is separate these two analyses of jurisdiction. And we know this, we know from cases like Christodoulou, and I'll briefly explain what that says. It says that the medical provider has an independent cause of action. So whatever the jurisdictional analysis is for the injured worker is separate from what the jurisdictional analysis is for the medical provider, because they have an independent cause of action. So on the other side of the fence, the argument is, well, if you can't, if the Workers' Compensation Court can't oversee the injured worker's claim because they're employed out of state or their injury occurred out of state, they should not be able to hear the medical provider's dispute. And from what we understand, this was not an issue when it was before the Superior Court, so before 2012. But after 2012, when the Workers' Compensation Court gets exclusive jurisdiction to oversee these matters, it now becomes an issue. So the other side on the other side of the fence, they're saying whatever the jurisdiction parameters are for the injured worker should be imposed on the medical provider. Our position is very much different, and the current case law is supporting us, and most of the written decisions on this issue also support us. So let's talk about where we are in terms of the case law now and the medical provider's position. So the medical provider's position is it's a contract dispute. So wherever the breach of contract occurred, wherever the injury occurred, is where the medical provider can seek redress for these reimbursement disputes. So we know for all these claims, the treatment occurs in New Jersey. This is a contract claim. There was a breach of contract because payment wasn't administered based on the laws of the state. So we're bringing this action into the court, into the New Jersey court system. We recently had a victory with the Supreme Court where the issue was statute of limitations. Now, it might be a separate issue, but it's still a jurisdictional issue. And what's key in the recent Supreme Court decision is that they treated the dispute for reimbursement as a contract. So if the courts are treating it as a contract, then the jurisdictional analysis should also be based on how contracts are treated. And contracts are treated based on where the situs of the breach was, where the breach of payment occurred. And that for the most part, is always New Jersey. The EOBs are delivered in New Jersey, the payments are rendered in New Jersey, the disputes are filed in New Jersey, and of course the treatment occurs in the state of New Jersey. So our position is that the breach of contract occurs in the state. This is a breach of contract action. It is independent of the workers' compensation claim of the injured worker. And any New Jersey court, any workers' compensation court should be able to oversee these matters because they have exclusive jurisdiction pursuant to the statute, which I was citing to a little bit earlier on. So some other language that was relevant in the Supreme Court decision regarding statute of limitations is that they were taking into account the plain meaning of the statute. And the plain meaning of the statute is the workers' compensation court has exclusive jurisdiction to oversee any dispute of reimbursement to a medical provider for a work-related injury. So, you know, there is a sort of a gradient of a continuum of where judges land. You know, a set of judges land on, they favor the position that if we don't have jurisdiction over the injured worker, we don't have jurisdiction over the medical provider. And then we have the other side that says, well, if we have it's an independent cause of action, so it's irrelevant whether or not the injured worker filed a claim here or whether or not we have jurisdiction over the injured worker. We have jurisdiction over the medical provider dispute always because the treatment occurred here, the injury occurred here. This is a breach of contract action. So finally, I just want to go over a few of the judges who have ruled on this issue and kind of what the fact patterns were and what medical providers can take from this. We know that in the southern vicinages, and Iwana is going to speak on this a little bit more, most of the judges have favored this position that this is a contract claim. And since the treatment was rendered in New Jersey, we're going to treat it like a contract claim and oversee the reimbursement dispute. So we see cases in Toms River, we see cases in Freehold that all are favoring our position that if the breach of contract occurs in the state, then the laws of the state should be applied, and the workers' compensation court with exclusive jurisdiction has the ability to oversee these disputes. We also are seeing some favorable judges in North Jersey, in Patterson, in Jersey City, all of whom rule the same way. This is an independent cause of action. It has nothing to do with the injured worker. And the basis of our analysis is going to be contract. The breach of a contract occurred here. This is an independent claim, and we're going to oversee it. In terms of reimbursement, you know, these are two separate issues, not to get too much into the nitty-gritties, but the first question of law is whether there's jurisdiction. Can the court hear this claim? And then the second question is, well, now we're overseeing this claim. How should the payment be made? Should it be based on New Jersey, UCR, or should it be based on a fee schedule from Florida or New York or Pennsylvania? And we have, you know, a very interesting case pending before the appellate division regarding subject matter jurisdiction. And in that instance, the injury occurred in Pennsylvania. They had a workers' compensation claim in Pennsylvania, and they sought treatment in New Jersey, the injured worker, where there were various bills. There were bills from the hospital. There was bills from the treating physician. There was bills from the anesthesiologist. And the anesthesiologist, for example, wasn't paid anything in that instance, right? So can the court hear the anesthesiologist's claim? Can the New Jersey court hear the anesthesiologist's claim when they treated the patient in New Jersey? Or does the anesthesiologist now have to go all the way to Pennsylvania, where the injured worker has their workers' compensation claim for benefits, and litigate their payment dispute? So our position, which is now I feel supported by some Supreme Court law, well, Christodoulou, of course, and now the statute of limitation decision, is that this is a breach of contract claim, and the court has subject matter jurisdiction. And when you look at the plain meaning of the statute, that the court has exclusive jurisdiction to oversee these claims, these medical provider disputes, although the workers' compensation claim for the injured worker is out of state, fall squarely within the jurisdiction of the court, regardless of it being a contract claim. We know that workers' compensation courts do consider other claims beyond the claim for benefits of the injured worker. And just because it's a contract claim doesn't mean that the court can't oversee it. So that's sort of the gist of what's happening in subject matter jurisdiction. Now, there's also another aspect to this, that's personal jurisdiction, whether or not there's jurisdiction over the employer, because that is the person that you're suing for this reimbursement dispute at the end of the day, because they are required to make payments on these bills where the injury has occurred at work. So the question is, does the court now have jurisdiction over the employer? So the employer could be in New York, they could be in Pennsylvania, they can be in Florida. And what connections to the state are required for them to oversee these claims where the employers are out of state? The question of jurisdiction has two aspects. It has subject matter jurisdiction, and which will usually in this case it stems from the statute, and that's what I was discussing in terms of the plain meaning of the statute, and what exclusive jurisdiction means and how it should be interpreted. That's subject matter jurisdiction. And now the next aspect of jurisdiction, which is personal jurisdiction, is, do we have jurisdiction over the employer? And Krista is going to talk about that a little bit more. So Krista, I'm going to turn the mic over to you if you want to discuss personal jurisdiction.
Yes.
I'll let Krista take over.
Raj and Krista, but before we go to Krista,
yes,
I'd like to just maybe have to discuss one aspect of this that you kind of touched on. You mentioned the anesthesiologist in the case that's before the courts. Maybe you can help explain to the audience, does it, and I know some of the respondents are alleging that because New Jersey reimburses based on UCR, and because other states have fee schedules that aren't as beneficial to medical providers, some of the respondents, formally or informally, have suggested that some patients are coming across the river and being directed to do so just so that medical providers can get greater reimbursement. Given that context and that accusation, which we think is, of course, bogus, is there a difference in the type of medical provider in New Jersey that has a stronger case versus others? So for a surgery, you have the surgeon, you have the anesthesiologist, you have maybe intraoperative monitoring, you have the facility. So is the jurisdictional analysis different from a subject matter jurisdiction point of view, depending upon the nature of the medical provider itself?
Yeah, thank you for that question. Absolutely. So yes, there is a difference, right? So we know for ER cases, for emergency room cases, usually hospital cases, judges are more favorable, even if they're on the other side of the fence in terms of determining jurisdiction based on the injured worker's claim. If it's an ER case, judges are almost always more favorable and will consider the reimbursement dispute. When it comes to elective surgeries, and this especially has to do with facility bills, that's where we start to see some challenges. In the case of Pennsylvania, the Pennsylvania case that's up on appeal, the person did get some elective treatment in, I believe, Morristown Hospital. And there were various treating physicians that were part of that treatment. So the elective surgery would be, although we don't see a distinction, and a lot of judges who have ruled favorably say that there is no distinction between the two fact patterns, elective surgery seem to be facing more of an uphill battle when it comes to convincing judges that there is jurisdiction compared to ER cases where we don't see as much pushback from judges.
Got it. Okay, Krista?
Yes, can I jump in? So hi everyone, I'm going to talk to you about personal jurisdiction. Tom and Raj talked about it a bit, but I just want to reinforce exactly what that is and explain it a little bit better. So personal jurisdiction is, for us, is jurisdiction over the injured worker, the patient's employer. This gets analyzed in court in two different ways. The first way is general jurisdiction, which would be where is the employer at home? So this would be if Whole Foods is headquartered in New Jersey, we can make the argument that the court would have personal general jurisdiction over them because they have a headquarters there. They could reasonably expect to be hailed into court in New Jersey. The other way it's analyzed is specific jurisdiction, which has to do with when the activity or the occurrence involving the defendant takes place in New Jersey. So this would be, for example, Whole Foods, say Whole Foods is headquartered in New York, but the injury happened in New Jersey. This specific, we would have jurisdiction because the specific activity that's giving rise to the cause of action occurred in New Jersey. So that's the two different ways personal jurisdiction is analyzed, general and specific. And then I know Raj talked about some of the fact patterns and which ones are the most favorable. So definitely by far, ER is the most favorable fact pattern. So this would be like a New York construction company on a job site in New Jersey, or some kind of company that's incorporated in New York, but doing business in New Jersey where the accident happened. We have the most success in resolving these because they want them to go back to New York to go to the emergency room if they're really injured, you know, not really. So the least favorable fact pattern would be a New York resident who works in New York and then only goes to New Jersey for a shoulder surgery. So like Raj was saying, there's always, we hear speculation from the respondents. Why did they go to New Jersey for this surgery? Why did they just do it in New York? They just want UCR. But we know that there are myriad legitimate reasons for that. It might be the doctor scheduling, quality of medical equipment at one facility compared to another, maybe the staff or resources or something like that. So in sum, the most favorable fact pattern would be ER treatment for sure. And then
Krista, that dovetails nicely with a question we have from Dr. Jacobs. Perhaps you can address this because
yes,
you're right there. The patient is injured in New York State in Nanuet. For example, they come to the ER, a New Jersey hospital. And is there a jurisdiction issue? The patient was brought to the New Jersey ER because they were close to the border.
If there is any contact with New York, the respondents are going to try and argue that it's a jurisdictional issue. But I think we have legitimate arguments in this great hypothetical. It was the closest hospital to him. You know, he can't be expected to drive further in New York just to stay in New York. So I think we have great arguments that the court would have jurisdiction over this case. But that's a great hypothetical.
Yeah, let me add to that a little bit. If it's ER, it totally removes the argument from the other side that somehow the patient is being brought across the border for greater reimbursement.
Right.
That's number one. And number two, there's a very, very compelling policy argument where, you know, states should be promoting on a financial basis as well as on other bases their ERs. So you don't want ERs in the state of New Jersey to be under reimbursed for ER treatment on the basis of some other state's fee schedule. So I think there's a New Jersey state policy reason that's very compelling where they would say, sorry, carrier, this is New Jersey, it's ER treatment. We are not going to tolerate our New Jersey ERs somehow being under reimbursed because of some other state's fee schedule. So I think both of those arguments are you know, both of those circumstances are available to us, which makes for a pretty compelling argument, I think.
Yeah, I agree. So then I want to talk a little bit about Hackensack, which is, so the state of New Jersey is broken up into vicinages. It's basically the same thing as counties. I think down south, though, there's less vicinages and more counties. Anyway, the vast majority of the cases with jurisdictional issues are in Hackensack. I think, and I don't know, don't quote me, but I think there's almost 3,000 in Hackensack that have jurisdictional issues, maybe somewhere between 2,000 and 3,000. Both of our appeals arise out of Hackensack. So just the lay of the land in Hackensack, there are 3 full-time judges and 2 that are on recall. Only one of the judges is really strongly against us. Everyone else has maybe heard an oral argument here or there, but haven't really firmly opposed our position as much as one judge has. And then still, most of them are undecided. But in the South is where we find most of the judges that do find in our favor. And Ioana's going to talk a little bit more about those judges and also about how we're able to settle some of these jurisdictional claims. So I want to hand it over to my dear friend Ioana. Oh, you're muted.
Can you hear me now?
Yes.
Okay, good. Hello, everyone. I'm Ioana, and I'm going to very briefly touch on the jurisdiction issue with regard to the southern vicinages. As my colleagues just mentioned, having a claim that is plagued with the nefarious jurisdiction issues sometimes really slows down the settlement process. Fortunately, in the southern vicinages, such as Toms River, Camden, Atlantic City, Bridgeton, and Freehold, those are all of them. Yeah, those are all of them. And Freehold, we have a lot more success with settling jurisdiction claims without much opposition from the respondent attorneys. In comparison with the northern vicinages, where they deal a lot with New York cases, the jurisdiction issues seem to be occurring more with our other neighboring friendly state of Pennsylvania and the southern vicinages. But that doesn't mean we don't also down south. I think a reason it might be easier to settle jurisdiction cases in the South with Pennsylvania cases specifically is possibly due to the Pennsylvania fee schedule being a lot more forgiving than the New York fee schedule, but it still sucks, so it's not that much better. That might be a little bit of a factor at deciding to meet in the middle during negotiations. Another important reason, though, that we could settle a lot more jurisdiction cases in the South is due to the amount of favorable decisions from the Southern judges that we have thus far. Our first successful jurisdiction decision was in Freehold by Judge Leslie Barrick, and her decision was actually published in Westlaw. Westlaw, for those of you who don't know, is an online legal research tool that lawyers, law firms, and legal professionals use to conduct their research when writing papers and briefs, or simply just preparing an argument. She's very proud of her decision being published and always refers to it when a respondent files a motion to dismiss on a jurisdiction claim. So it's great if we end up having one of our cases land in her court. Another Freehold judge on our side is Judge Martino, and he also issued a favorable decision. We also have Judge Mulvaney from Toms River leaning in our direction, hasn't yet published a decision. And then Judge Chirkos from Toms River has also issued a favorable decision. And our very own Raj, he handled the oral argument with Judge Chirkos in Toms River and was successful. Raj, why don't you fill us in a little bit on what transpired with that argument and why you were so successful with it?
Thank you for that, Ioana. It was Judge Chirkos. So that was a very interesting oral argument because it had medical providers with patients from all over the country. We had a patient from Texas in that case. We had a patient from Florida. We had a patient from New York. We had a patient from Pennsylvania. And all those cases was consolidated into this question of jurisdiction. You have these patients that are residing or were employed out of state. They were injured out of state. How does the court now deal with these medical bills? And we represented an ER hospital in that instance. A little bit about that. The injury occurred in New York. They went to they went to receive treatment in a hospital in Jersey City, and then they made their way down to their residence in South Jersey. And the question was, well, was a medical provider put on notice that they would have to accept a fee schedule out of state when they treated someone, especially on an ER basis? So Judge Chircos ruled. I mean, the other fact patterns were all elective, right? So Judge Chircos ruled that it didn't matter. It didn't matter if it was ER, whether it was ER or elective or what type of treatment it was, unless the medical provider is put on some sort of notice that they have to abide by an out-of-state fee schedule, is just not fair. And just like the other judges that have ruled in our favor, and we've done oral arguments all over the state now, from Hackensack to Toms River to Freehold to Patterson, they all rely on the plain meaning of the statute. And I think that's what I referred to before, which is, and I'll read it once more, it's exclusive jurisdiction for any disputed medical charge arising from any claim for compensation for a work-related injury or illness shall be vested in the division being workers' compensation court. So all the judges read the plain meaning of this statute to be that the workers' compensation court has exclusive jurisdiction to hear these claims, irrespective of where the injury occurred or where the worker filed their workers' compensation claim for benefits. And that's the little story there. Back to you, Juan.
Thank you, Raj. That was a beautiful story. That was pretty much a little snippet about the southern vicinages and how we're handling the cases there. So I will shoot it back over to Tom.
Thank you, guys.
Peace out.
Thank you, guys. Let me put it out, not just to the audience, but Raj, Iwana, Krista, are there any nuances that you think would be worthwhile for the audience beyond the presentations you already gave? For example, I think it's very important, and I've had numerous conversations with surgeons where they should, it might be smart of them to be mindful of some of these carrier allegations where, carriers are very quick to say, hey, the surgeon is just bringing the patient across the river to get reimbursement somehow. You have many surgeons that operate in New York and in New Jersey. They have privileges at New York facilities as well as New Jersey facilities. And every time I have a conversation with a surgeon about, why a patient was treated in New Jersey at a New Jersey facility versus a New York facility, they always inevitably have given me a very patient-centered reason for it, okay? So, and let me give you some examples about that. Not every facility is the same, so some facilities are more appropriate than others in terms of how state-of-the-art they might be. So some surgeons with some surgeries will bring a patient to a New Jersey hospital or perhaps a New Jersey surgery center because the facilities where they have privileges in New York are less accommodating to the patient. I've heard doctors explain to me about waiting times, that some of the facilities in New York, because don't forget, patients have to not eat for a certain period of time. So there are certain patients that may be diabetic or may be obese, and the fact that the waiting time might be unnecessarily longer in New York than in New Jersey becomes a motivation for them to schedule in New Jersey. Plus the convenience of the patient. There are patients that live upstate New York where it's much more convenient for them to drive to North Jersey to have a procedure done than to go into Manhattan. So there's a whole bunch of patient-centered reasons for why surgeries are scheduled, where they're scheduled, and when they're scheduled. So I've been trying to encourage the providers I've spoken to, the surgeons in particular, to to document the reasons why a surgery is being scheduled in a particular place at a particular time. Maybe a patient's only available on a Wednesday for a procedure because they work, And on Wednesdays, the doctor only has privileges in, X facility, and that facility happens to be New Jersey. So there's a whole host of reasons why surgeries could be taking place in New Jersey. And so I just want to put that out there. And guys, the rest of the team, is there anything you would offer medical providers just in terms of guidance to kind of help with the issue?
Sure. I can start, and then Krista, if you wanna fill our audience in as well. So I think you're exactly right, Tom. I think the most important thing for medical providers to do is document the reasoning why the patients have ended up in New Jersey. Practically, how a lot of these conferences work is they end up becoming policy questions. Although judges will a lot of times say, I'm relying on the statute, or this is how I interpret the statute, they do take into consideration all these soft factors, the rationale, the reasoning. Why is this person in New Jersey when they could have received treatment in New York or Pennsylvania or whatever it is? And Tom, it's a roll of a dice. We don't know which judge in which vicinage is going to end up overseeing these claims. So we don't know whether or not from the get-go jurisdiction will be favorable on a particular claim, or ultimately it'll be dismissed. Ultimately, it could end up with any judge. So I think documenting the reasoning, the rationale behind bringing the patient to New Jersey, if for some reason they reside out of state or their injury occurred out of state, is sort of key in these instances, especially when judges are making decisions based on public policy, and they do find these factors to be persuasive. Although they might not be legal factors, they are very helpful in persuading the judge.
I agree with that. I think having that information would be very helpful, especially if we had it right away. That way, we could respond immediately as soon as respondent raises that argument with our legitimate rationale for why the patient was brought to New Jersey. And we know a lot of the time, we know it's legitimate, but we don't know what the legitimate reason is. So that would really help us if we could have that information. So I definitely agree with you on that, Raj.
Right. Joanna, anything to add? No?
I think my colleagues did a fantastic job of covering all bases.
Wow, they were so impressive, you're speechless. Okay, I don't see any questions at the moment. So unless any of you out there have questions, I think we can wrap up. Thank you, panelists. You guys were great, and you're obviously you are very much engrossed in the substance of these issues. And of course, I hope everyone out there wishes us luck in that regard. We have 2 cases pending in front of the courts, and the courts will no doubt be speaking. It would have been sooner. This probably would delay things. The crisis will no doubt delay things to some extent, but hopefully we'll hear from the courts soon, and we'll get some resolution on some of these issues. So thank you, panelists. Thank you, audience, for coming. We hope you found it informative and enjoyable. Krista, thank you so much for being in the background. Mark Winters, thank you for helping out with the logistics of all of this, including the promotion. So with that, if nobody has anything else to add, we will say goodbye. And everybody out there, please be safe. And we hope this was beneficial. Thank you all.
Thank you, everyone.
Bye, guys.
Thank you. Bye-bye.
See you, everyone. Bye.